Hi, thanks for joining us on YouTube. While the nation awaits the U.S. Supreme Court's decisions on immigration, gun rights, and abortion, the nation's top court already has cleaned its slate of cases crucial to the U.S. and international business communities. An unprecedented 6 arbitration cases, 5 arguments with 2 international cases consolidated, have been briefed, argued, and decided in this 2021-2022 term, to this week, wrapping up the year on arbitration on June 13 and June 15. This is welcome. Arbitration is an essential tool for businesses to resolve disputes efficiently and purposefully. Arbitration needs this fine-tuning, and it needs SCOTUS supervision. And the court, indirectly over the 5 opinions, addressed the issues that have seen the process of arbitration preceded by the adjective forced. Adhesion contracts bind consumers and employees to arbitration where they have little or no bargaining power, and they've made a process dealing with business and government conflicts that dates back centuries very controversial, even in matters where the parties are sophisticated and very large corporations. And in that regard, this court has recast its own treatment of the Federal Arbitration Act, reinvigorating past moves to focus on the text of the nearly century-old law. 3 of the 6 cases we've heard this term were rooted in employment law, and very surprisingly, in each case, 2 were on jurisdiction and then the reach of the Federal Arbitration Act's terms, and another one was on interpreting judicial FAA standards. In those 3 cases, the employees' matters were revitalized. The individuals filing suit against big companies won their cases and were allowed to proceed in court, a very unusual move in recent Supreme Court jurisprudence. In the consolidated international cases, which prohibited the use of U.S. law for discovery and overseas arbitration matters, they similarly were based heavily on textual readings. At a minimum, the court provided a path this term for addressing arbitration cases. It actually began in 2019 in another employment case holding that independent contractors were exempt from the Federal Arbitration Act's arbitration requirements under the terms of the statute, Section 1. So the path that's been provided is to stick close to the text, and this Supreme Court is going to be receptive, often unanimously or very close to it. The final of the cases decided this week, as we record just yesterday, was more of a traditional preemption of state law in favor of the Federal Arbitration Act. But the court also kept alive the class processes that we know this court does not love. They allowed them under the California Private Attorney General's Act, barely, but suggesting further state court interpretation or California legislating is going to keep that path open. Now, we can't go into all 6 of these cases in detail here on YouTube, but we've provided links below to our CPR Speaks blog where we have previews, argument reviews, and detailed case results for all the cases. Thanks for joining us. My name's Russ Bleemer. I edit and write Alternatives to the High Cost of Litigation. It's a newsletter by the CPR Institute. It's published by John Wiley and Sons. And I'm joined by University of North Texas, Dallas College of Law Professor of Practice and Assistant Director of Experiential Education, Angela Downs, who will come back on momentarily, and veteran Texas attorney arbitrator Richard Faulkner, who've watched the Supreme Court cases for us in recent years in CPR forums, including here on YouTube. I want to thank them both for returning and send regards to our New York attorney arbitrator friend, Phil Lurie Jr., who was unable to join us like he has in the past. Now, we'd like to try to develop an overview, if it's possible, amidst such a large body of judicial arbitration work that has emerged from the Supreme Court in the past couple of weeks. Hopefully, we can pull out a few of those cases. Professor Downs, you didn't miss anything. Welcome back. I know you had said that Viking River was on your mind. That was the California Private Attorney General's Act case that was just decided yesterday as of this taping that I mentioned. I know you have comments on the effect it has on states, how it's not going to affect unionized workers, and how it's also not going to affect individuals who are not in unions as well. What are your thoughts on the significance of that case and how it relates to all of the other arbitration work the court has done this term?
Oh, there she goes. Angela, Mike, there you go.
Okay,
There you go.
Try this again.
Thank you.
Thank you for the opportunity to participate and in this forum at CPR Speaks. Definitely, Viking River Cruises has been top of mind with the decision that came out yesterday from the Supreme Court. And I think it's a really interesting interpretation of the law and the Federal Arbitration Act, in that California had focused on a way to ensure that folks who had become involved with arbitration agreements had a way out. In essence, even though they had signed these arbitration agreements, they were able to step aside from those agreements and proceed with litigation. And our Supreme Court has said that that is not the case, that they want to really push back on some of the power that had been affirmed by the PAGA in California, to really say, no, you've signed this arbitration agreement as part of a contract, and you're going to have to stand by that. And I was a little surprised by this, because generally we do have a court that does tend to favor states and providing states with an opportunity to make decisions on things that affect their constituents individually. So I was a little surprised by that. But the good news is that there are still ways, even for those folks who might feel that they would not have the opportunity to be released from an arbitration agreement that they had signed, that perhaps they didn't understand, in that if they are members of a union, they're not going to be affected, because unions do collective bargaining and do collective agreements. And so they have the ability to navigate arbitration agreements. And oftentimes, if there is a union that's involved with an arbitration and representing those that fall under the purview of the union, they have the ability to have those protections where they'll be able to determine their form, and maybe they will not have to go forward with the Federal Arbitration Act. So there's some protections there, but it is something that, for a lot of cases, as you said, Russ, we're focused on employment and how we wanted to ensure that folks had opportunities to be heard, because as we know, these arbitration agreements are woven in to employment contracts when you sign in, and a lot of folks don't understand what they're signing. But I think the court is signaling that this Arbitration Act needs to stand. It's something that that they have really put some new fire to say that it's important, and it's something that we really need to be in consideration if we're going to go forward with arbitration.
That's great, Professor Downs. I really appreciate you bringing up the workers' perspective. You know, when we wrote up the case as it happened in real time yesterday and posted our story on it, the hands down categorical view is that business is delighted about this. There's an industry group that's linked in our CPR Speaks report that was formed solely to combat PAGA. They did not get the victory that they thought they would. PAGA is still on the books and is potentially about to be either reinterpreted by the California courts, as Sonia Sotomayor suggested in her concurrence, or it's going to be rewritten by the legislature. It's still going to go on. But business is very, very happy about this decision. That being said, Professor Downs, aren't there going to be cases where employees will enter into arbitration, perhaps, and welcome it on one-to-one situations for their own matters? For example, in employment programs, it's now authorized that mandatory under Epic Systems versus Lewis, and now reasserted in yesterday's decision that permits that. Is it possible this is going to make arbitration better for employees?
Well, I mean, I think one of the takeaways from the case is that there's an indication that for employers, they may be able to use a properly drafted arbitration agreement And that's, at least for now. We know that California is going to go back and, as you said, reinterpret and look to see. But it's going to allow representation claims to proceed, and those will be separate from individual claims. And employers with operations in California, arbitration agreements, they're probably going to be looking to update their agreements to ensure that they are in compliance. But I think it's something that it's a wait and see, but it's definitely going to impact how business is done. I think businesses are going to be looking at their arbitration agreements. And I think individuals hopefully will look to pay more attention to what they're signing.
Mhm. There's definitely some updating of agreements that's going to go on the management side, because the court did make it clear those representative actions do continue. The question is how they continue. The court leaves that, as we noted yesterday, in limbo. I want to thank Professor Downs is speaking to us from awaiting a court hearing, and thank you for putting up with the Wi-Fi there. It's very nice of you to do that. Rick, along the lines of Viking River and updating those programs, I know you're concerned about all 6 of these cases, about the costs to business of using arbitration, and it's your view that it threatens the utility of it as an alternative to court. Feel free to start with Viking River, but which of these cases heighten that concern about the cost of arbitration, or maybe reduce it?
Well, none of them reduce the concern about the cost of arbitration. Quite the contrary. The subtlety and the distinctions amongst the 6 opinions in Viking River are distinctions that only a Jesuit or a rabbi could fully enjoy. The rest of us are looking at this going, oh my God, there were, 1 dissent. So we had 7 justices and we got 6 opinions effectively. And that is not exactly a model of clarity. What the court did do was reemphasize the issues of consent and how the fundamental aspect of the FAA involves consent to arbitration. And it reiterated a number of points, but it also expressly, in the concurrence, invited the California legislature to become active again, and the California courts to perhaps reinterpret PAGA. Anytime you invite a legislature to make changes, this is, potentially very disruptive. We joke in Texas, our legislature is in session for 180 days every 2 years, and it ought to be reversed, 2 days every 180 years. Salutary for Congress too. But what we have is a continuing expansion of the cost of arbitration, and it is becoming so burdensome on the typical businesses I represent, small and mid-sized businesses, that arbitration is almost unaffordable. Uber lost in its attempt to appeal the American Arbitration Association's $91 million bill. Many of the plaintiffs' lawyers have figured out how to weaponize the arbitration rules of certain organizations so that they now are filing thousands of individual arbitrations. They're actually managing to make class actions look desirable. And the Supreme Court is kind of still fixated on the ability of arbitration to stop multi-party or class or representative actions. And, it's assuming a world of arbitration that hasn't existed for.
Rick, isn't it ironic that in the Saxon, Southwest Airlines versus Saxon case decided a few weeks ago, the court actually, in the view of business, expanded the size of the exemption for transportation workers. So isn't it kind of ironic for this court that, they did it yesterday in Viking River, somehow vaguely preserving collective actions in Southwest versus Saxon, creating potential classes down the road and removing them from arbitration under a plain text reading?
Right. And when you look at the fact that the court has returned time and time again to a hypertextual analysis, every word, every comma now has significance in the FAA, but also in both Viking and Morgan v. Sundance And in the Southwest Airlines v. Saxon case, the court has left ajar opportunities for an expansion of exemptions to the FAA, which will be litigated. I mean, you know, what exactly is a worker engaged in interstate commerce now? A baggage handler supervisor who only occasionally touched or moved baggage is now exempt from the FAA. How far does that go? Do Amazon?
There was a footnote, it basically inviting the app companies, the app commerce companies, to make that case.
I know. And I have a feeling that litigation, there's going to be so much additional litigation over arbitration. It is becoming effectively a guarantee of 3 lawsuits in one. A lawsuit over if anyone has agreed to arbitrate, another one over what's been agreed to arbitrate, and then motions to vacate, which now, with another one of the cases the Supreme Court gave us, Bajero, may very well be brought in the state courts without the ability to bring a motion to confirm an arbitration award in federal court if the court used the look-through jurisdiction to compel arbitration in the first place. So
Rick, thanks for, let me just fill in on Badgero. Thanks for bringing it up. That's ancient history with this court. That was the first of the decisions way back in the old days of the end of March. In that case, the court said that you can go into federal court to get an arbitration, to compel arbitration, but you can't enforce the award in federal court. You can't overturn the award in federal court under sections 9 and 10. Those were not specified in the statute and by default become state court matters, which kind of sets it up for a lot more state court activity throughout the entire course of the case, and a lot more federal court activity as well. You could file in federal court, and the federal court to compel. Perhaps the federal court will maintain jurisdiction. That was an open question in Badgero. And that, by the way, again, Professor Down, that was an employment case as well. It was a harassment case. The person in Louisiana against a big national broker, Ameriprise, lost her case. And then when the case went to be confirmed in federal court, this challenge came up. And the decision, I think I can say, was a big surprise for most people. Most people assumed that if it worked for 4 in federal court, it would work for 9 and 10, and it did not. So I think, Professor Downs, there's another textual challenge coming up down the road.
I think there is, and if we look at the cases that have come down from the Supreme Court for this term with related to arbitration, this, you know, the cases, the decisions that have been rendered are in line with kind of what I've been calling as the kind of the steady march where the Supreme Court has continued to kind of close the door to courts and those lawsuits about reinterpreting reinterpreting states' rights, but they've really been upholding private arbitration as a to resolve costly disputes. And, you know, and we've seen it in a lot of different contexts. We've seen it with employment cases. We've seen it with banks, credit cards, retail purchases. So there's nothing here that's really too surprising, because if we analyze all of the cases that have come down this term, they're pretty much in line with what's been happening in the courts for quite some time. Really looking to shore up the effect of the Federal Arbitration Act and really saying, states, hold back. We already have the FAA in place. And so because it's in place, you're not going to be able to work around that and take those individualized suits.
People have asked me whether or not this is a give back. These textual decisions all of a sudden are coming up on the employee side. And this is a court that has not been sympathetic to the individual's contentions about arbitration, whatever they happen to be. And my response has been, as I alluded to before, the 2019 case New Prime versus Oliveira, where that Section 1 exemption was shown to include an independent contractor. Therefore, he didn't have to arbitrate. Now we have the baggage handler in Southwest Airlines versus Saxon, who is also a transportation worker who doesn't have to arbitrate. It's interesting that the court, following its own path, has now all of a sudden veered in another direction.
Well, I think what you need to look at is the court has emphasized equal treatment. And part of what these decisions have done is effectively overturn almost 50 years of what we thought was settled jurisprudence regarding the federal policy in favor of arbitration. The court has now informed us that means nothing more than that arbitration clauses must be treated equally with all other contract clauses, i.e., they can't be discriminated against directly or indirectly. And that has led, with a hypertextualist approach to the statute, to some really surprising wins for employees. And I think it also means that the court is really embracing a federalist viewpoint that is recognizing contracts are basically within the control of the states, state legislatures, and state courts. And what the law means with regards to those contracts, for the most part, is defined and controlled by the states. The court is making it clear it will look at state law, it will look at the nuances and the actual contents of the state statutes, but state law is really where the analysis and Viking focused. In addition, many federal judges simply regard federal opinions interpreting state law under diversity as advisory, because the authoritative determinations of those of the states, and in the concurrence you saw the court saying we need to look at what the California legislature may do, what the California courts may do. And when you have a reference back to California law, which is very different than, say, Texas law, Louisiana law, New York law, we're going to have a heck of a lot of litigation coming down the pike on these things, because the definition of a worker in interstate commerce has been expanded. We don't know how far. We have issues of who exactly are the parties that can be or cannot be participating in arbitrations. The Viking River decision invites examination of many of those issues. And if you defer to California law, for example, you have to look at who were the intended parties at the time the contract was entered into. So what happens with the boilerplate that everybody used to throw in, that you probably shouldn't throw in anymore, of successors, assigns, heirs, representatives, ad infinitum? Does that trigger the concerns that were articulated by Professor Horton with regards to infinite arbitration clauses? Clearly, businesses have generally liked to try to impose those. Consumers are going, how did I agree to arbitrate with somebody that hasn't even been determined until 10 years in the future? And those are legitimate concerns. I don't think the consumer can or has, or a small business can or has agreed to arbitrate with anybody other than whoever signed the contract. But we may find out otherwise.
Rick, I want to give you and Angela 30 seconds to a minute each to wrap up, if there was any overview we could say about this. But I want to pick up at the beginning of your last statement for your end point. Is Justice Clarence Thomas, who yesterday in Viking River dissented, it was his 8th by my account. I'll stand corrected if I'm wrong. It was the 8th time he has said that Federal Arbitration Act questions are not state court matters. Don't decide that. They belong in the state courts. Your answer before sort of said that it looks like these key issues that are coming about the limits of arbitration under the Federal Arbitration Act or not are going to be state court matters going forward. Is Justice Thomas's longstanding view now about to be the arbitration practice reality?
I think it may very well be, because we are going to have legislatures taking action. The California legislature has never needed much of an invitation to try to oppose arbitration. Remember, they also tried to criminalize the use of arbitration, and they're not the only ones. I have friends who were running for attorney general, did not succeed in the runoffs, but we were approached by activists to open criminal investigations into the use of arbitration and into ADR organizations. Some of the activists are really determined to go after arbitration, and that's going to be reflected in legislatures. We're safe in Texas. Our legislature is going to stay conservative for a long time. California is anybody's guess, and much of the rest of the country is anybody's guess. But remember, even Congress passed the law amending the FAA to prevent the arbitration of sex abuse and sex harassment cases. And interestingly enough, in 402B, it forbid the arbitration of arbitrability and requires determinations of arbitrability to be made by federal judges, which I think is an acknowledgement that there are huge problems in arbitrators determining arbitrability. And I don't care what is incorporated by reference in rules that only the three of us read. The reality is consumers and employees have no idea what's in arbitration rules.
That is another issue on who decides whether a case is arbitrated. That's coming back to the Supreme Court. Whether they take it or not remains to be seen. Thanks for that summary. It's another good reason why it's important for the court to have taken 6 cases this year and to continue to look at arbitration, because when you're talking about criminalizing a process that is so important for commercial efficacy generally, and to resolve disputes and get matters out of courts and let business continue with its main purpose, it's important that arbitration continue to be refined and the practice maintained and the standards set. And of course, as you point out, many people believe that had gone off the rails, at least in some of the areas involving individuals. Professor Downs, before you're called into your hearing, please close us out.
Absolutely. Well, there's one thing I do want to highlight, and Rick brought this up, really saying, California, it's kind of anybody's game. But I do want folks to know that the Attorney General in California, Rob Bonta, actually, he did call the decision in a Viking River cruise. He said it was disappointing. But he did say the key aspects of their PAGA do remain in effect, and he's still saying it's the law in our state. So I think with that, they're inviting some legislation. He did also go on to say that workers can continue to bring claims on behalf of others if they did not agree to invite for some continued legislation to really look to see the interpretation of where arbitration is going to land in their state. And I do have to agree that for consumers really don't know what they're signing with a lot of these arbitration agreements. So there's definitely an education piece that probably needs to happen. The consumers are aware of what they're signing and the ramifications of these.
And that's great. As you're breaking up a little bit, it brings us back to the beginning that there is more to come under Viking River on a limited basis at the court. Business interests have advocated on the education point as well for consumers, and there may be a role down the road for the Consumer Financial Protection Bureau as well on that. Thank you both for joining in summing up as best we could all of the activity very quickly. Please click on the links below for details on the cases. In yesterday's Viking River case, we did include a link to Attorney General Banta's statement. Thank you both.
Thanks, Russ.
Broke my voice right out. Appreciate it. Bye-bye.
Thanks, Russ.